Alrighty, good afternoon, everyone. You're right at the hour mark. Good afternoon to everyone on the East Coast. Good morning in various shades for everyone west of here. My name is Kedar Sankaraman. I'm with ACT. We're a global trade association for small and medium tech companies, and I work on AI competition and standards policy. With that, to kick us into the weekend, in this webinar today, we're going to be talking about antitrust law. What a fun topic to discuss on Friday, but it is quite interesting, and it is coming under more changes and potential changes in the US, in particular at the state level. And today we're going to be talking about three proposals, two bills, and one proposal of the California Law Revision Commission concerning antitrust and competition law. And we hope to bring at ACT the small business voice to the table, which is often not heard in the broad scheme of antitrust policy. And just to give a brief overview of the three proposals before I introduce the panel, we have AB 1776, which is the Compete Act, which passed the California Assembly Judiciary Committee this week. This would add or amend the Cartwright Act to add single firm conduct mandates, which previously didn't exist in California under the Cartwright Act. It arguably existed under California unfair competition laws, but not specifically under the Cartwright Act, which is where discussion will be focused today. This would notably go broader than federal single firm conduct law under Sherman Act Section 2, which courts have interpreted in various ways over the last 100 years. And the California proposal would move away from the federal approach and what is arguably a radical change to the law for conduct at the California state level. Second, we have SB 1074, which is the BASE Act, which is similar to, the mandates are similar to the EU's Digital Markets Act, in particular, the self-preferencing provisions of the Digital Markets Act, wherein it would designate specified companies based on thresholds of market power and revenue and so on, and add mandates on specific conduct. The mechanism by which it's implemented, it would be implemented is different than the EU in the sense that it does have an affirmative defense that firms can raise, but the threshold for meeting the affirmative defense is quite high, and that's something we'll be discussing further as well in the webinar today. And lastly, we have the California Law Revision Commission proposals on mergers and acquisitions policy. This is currently not before the legislature in California. It's with the CLRC. So it's coming a little bit further down the line in California potentially, but nonetheless, it's just as consequential as the other two, in the sense that it would codify various merger review thresholds that looks at market concentration metrics as inherently a negative viewpoint. And we will discuss that as well. The webinar will be primarily focused on the BASE Act and the Compete Act, but we will mention the merger reforms as well. And to discuss all of this, we have an eminent panel here. To start off with, we have Satya Marar, who is a research fellow at the Mercatus Center at George Mason University, and an AI and competition fellow at the Innovators Network. Satya has written extensively on the unintended consequences of ex-ante digital regulation, and he brings critical insight into how rules like the EU's DMA, Digital Markets Act, are already impacting competition and AI development globally. Thank you, Satya, for joining. Next, we have Dr. Ted Bolema, who is a senior fellow at the Mackinac Center for Public Policy and also an antitrust and competition fellow with the Innovators Network. We have two Innovators Network fellows here working in tandem. Ted brings deep expertise in the economic analysis of regulation and has been a leading voice on the importance of consumer welfare standard, particularly regarding the proper role of state-level antitrust enforcement. Thank you, Ted, for joining. Next, we have Bilal Sayed, who is counsel at Cadwater, Wickersham and Taft, and senior competition counsel at Tech Freedom, in addition to also being adjunct professor of law at the Antonin Scalia Law School at George Mason University, and at my alma mater, the Sandra Day O'Connor College of Law at Arizona State University. Bilal also brings invaluable experience, practical experience from his time at the FTC. Thank you, Bilal, for joining.
Thank you.
And then lastly, but not least, we have Ben Golombek from California, He is the Executive Vice President, Chief of Staff for Policy at the California Chamber of Commerce. Ben represents the broader California business community and will help for us today in grounding the conversation with the practical experiences of businesses in California as they face these legislative proposals. Thank you, Ben, for joining.
Thanks for having me.
So maybe to kick things off before we dig deep into the antitrust proposals and provisions, Bilal, could you set the stage for us and for the viewers about the specifics of where is the antitrust proposal situated? Like at what level, and what role do states play currently in the U.S. in antitrust enforcement? What is the role of federal law as well? And just, can you just give us a context for this?
Sure. So states play an active role in the enforcement of the antitrust laws. State attorney generals and state citizens of a state, can enforce or move to enforce the federal antitrust laws in federal court. Some states, most states, have some version of an antitrust law. Sometimes they mirror or nearly mirror the Sherman Act and the Clayton Act provisions of federal law. Sometimes they're broader, sometimes they're narrower. California is an example. It has a state level equivalent of a Sherman Act Section 1 restraint of trade law, but as we're discussing, they don't have a clear copy or state statute that overlaps with Sherman Act Section 2. The activity of the states, sort of ebbs and flows. When federal enforcers are active, the states often pair with the federal government in bringing antitrust cases, both under federal law and under their specific state law. When the federal government is not active, some states choose to step up their enforcement and sometimes expand their enforcement beyond what you might challenge under federal law. And I think we're in a period right now where the states believe that they need to step up their role in enforcing the antitrust laws, whether it be using federal antitrust law, Sherman Act and the Clayton Act, or using their own state laws.
Thank you for that intro and context. Ted, coming to you, Bilal briefly alluded to the breadth of federal and state law in terms of what kind of conduct they cover and the policy behind it. California courts have traditionally recognized that the Cartwright Act is broader than the federal Sherman Act in its interpretation of it. But in the US in particular, with single firm conduct in the last 50, 60 years, the consumer welfare standard has been predominant in the court's interpretation of the antitrust laws. Do you see, and the consumer welfare standard for context is places the consumer benefit competition at the center of it, not necessarily competitors. Do you see the current proposal with in California as going away from the consumer welfare standard? And do you see any potential broader implications for US policy beyond just California for these?
This appeared to be the intent of the statute, to move away from the consumer welfare standard. So kind of take us back to what we had in the 1950s and 1960s and into the 1970s, when we had much more activist sort of antitrust enforcement at the federal level that really focused on deterrence. And with the consumer welfare standard, we have more predictable rules. That's one of the features of it. And then we also have, focus on how consumers are actually affected. Yeah, you're right to point out that California is one of the states, like Bilal pointed out, that have somewhat broader enforcement or laws that go beyond the federal statutes in terms of creating liability. But until now, it hasn't been all that much further beyond. I mean, I've seen some cases like affecting middlemen, wholesalers or resellers who claim that they were hurt or got squeezed by their supplier, and then they couldn't pass on those the extra costs or the losses they took onto consumers. So under the consumer welfare standard, the consumers weren't affected, but there have been some California cases that found there could still be some liability for that. Well, I mean, yeah, this until now it's been in some relatively confined areas. This statute seems to go much broader than that. Also add that we had a wave of Supreme Court decisions about 20 years ago, and one of the themes that the Supreme Court was really pounding hard in them was on the importance of predictability, having predictable rules for companies so that they would know what they need to comply with. And so contained in this statute is language I think we'll talk about later about federal statutes not applying. I mean, it is pretty clearly a rejection of or attempt to reject this whole line of Supreme Court decisions that have really focused on that predictability.
And that's a good point. Like for ACT members in particular, who don't have compliance departments, they're often less than 10 people in the company. Like having legal certainty and legal predictability as they innovate in these, especially digital markets, is critical for their success. And on that note, Ben, coming to you from the perspective of California business communities, like what is the general reaction in the state with California attempting to create antitrust standards that are quite different from the federal approach? Do you have any reaction from the state business community?
I would describe it as hair on fire. I have certainly, here at the Chamber of Commerce, we weigh in on hundreds of bills every single year. And I have never seen a bill like this get as broad a group of stakeholders as freaked out as quickly as possible as we've seen here. I think we actually set a record for the most folks in opposition to a bill before a first policy committee hearing. And it came from every industry, like every sector of the economy. Didn't matter sort of where you came from, tech, banking, insurance, movies, doesn't really matter. Music, all of sort of the foundational life sciences, healthcare, all the foundational parts of the California economy are in strong opposition to it. Even groups that generally don't agree on things. So people are taking the threat very, very seriously. They're very, very concerned. I mean, it's great to see sort of the folks activated in this way and folks engaged in this way. I know at the end we'll talk a little bit about the Law Revision Commission. We can talk about sort of some of the stuff also coming down the line as well. But yeah, everybody is, I would describe it as just sort of five-alarm fire among folks here in California in terms of the broader business community. I know we've seen there have been narrower proposals in New York previously, so some industries were sort of familiar with what was coming because they dealt with it in New York. Obviously, here in California, we like to think of ourselves as pretty special. But I think once we saw this first bill get introduced, 1776, which we'll talk about, and then 1074 as well, I think it really sort of hit home with folks. And one of the things that's been really interesting to me also is we've heard so much from small businesses, and they've tried to portray this as, going after big business and fighting for small business. But in the committee hearing we had just earlier this week, there was actually more small business opposition than support. I think there were only like 8 or 9 small business companies in the whole state that came out in support of the bill. So we were certainly pleased to see that everybody sort of understood that, the issues this would create, these proposals would create, would not just impact big business, but every business in the state.
And that point was definitely borne out in the Judiciary Committee meeting you referred to, like just a amount of time that was spent on discussing this and people voicing their opinion. It certainly activated a lot of folks within the state and outside as well to weigh in. So just to clarify for the attendees, we're not talking about one single proposal in California, we're talking about 3. And the first one that we'd like to address is and dig dig deeper into is Assembly Bill 1776, which is the Compete Act, which would add single firm liability in California, which previously did not exist. So maybe Bilal, could you briefly give us an overview of 1776, the Compete Act? What does it actually do? How does it change the rules of single firm conduct? That's quite different from the federal approach as it's there right now.
Okay, there are a number of ways it's different. I think a key difference is that it establishes a single firm restraint of trade concept, which has no analog in the federal antitrust laws, and to my reading would significantly expand the conditions under which a firm who I think would not be described as a monopolist or would have a duty to deal with rivals or customers that it for whatever reason did not wish to deal with. So that's a significant expansion, right? There is a very narrow duty to deal under federal antitrust law, but it only falls upon firms with monopoly power. The California legislation would really extend that duty to deal down to much, much smaller entities, probably firms with some level of what you might call modest market power, firms with market shares in the range of 25 to 30%, the way I read the different materials. So that's a very significant and broad difference. The act, also in line with the recommendation of the California Law Revision Commission, would substantially undercut application of federal antitrust law as a way of interpreting conduct prohibited under state law, right? So the language of the bill very much mirrors federal Sherman Act Section 2, which prohibits monopolization, attempted monopolization, and conspiracy to monopolize, adding in some language to make clear that the state law would apply to monopsonization, the buy-side exercise of monopoly power, and also adds a few words about maintenance of monopoly power. But all these things are captured in federal law. But the most problematic aspect of the language or legislation with respect to monopoly behavior is that there are interpretive notes that would prevent the state courts or prohibit the state courts from relying on frameworks developed under federal law that sort of protect consumers really from the courts prohibiting conduct that probably, on balance, enhances consumer welfare and leads to lower prices, right? So, in a sense, antitrust has, for a long time, had a very difficult time treating discounting and low prices by monopolists as anti-competitive, right? Finally, the Supreme Court, corrected that interpretation and said, look, a key factor in competition is to drive prices down. And so we don't want to interpret the antitrust laws in a manner that imposes a significant risk of liability on any firm, but in particular, large firms with some sense of monopoly power, of discounting or cutting prices, right? Because that's the purpose of competition: lower prices, higher output, and greater innovation. So the state bill would sort of prohibit the courts from adopting that decision and the requirements that the federal courts have sent out for thinking about low pricing by a large firm.
Thank you for that. That's a great context for it, and in particularly about for ACT members, a key cornerstone of U.S. antitrust law is like balancing pro-competitive benefits with anti-competitive effects, and this is a key fact-specific inquiry where the laws have to be applied in specific context, and really nullifying decades of case law in applying this new framework in California is for ACT members in particular, it's quite concerning. And in this context, coming to you, Satya, thanks for waiting this far. Like startups like ACT members, they often compete by offering discounted pricing, by offering bundled services and exclusive partnerships. They partner up with other companies in the ecosystem as well. If AB 1776, especially with its removal of the market power threshold question, makes these arguably pro-competitive practices illegal, like what effect would that have on like startups and new entrants based on your experience in your studies?
Yeah, sure. So, it's kind of ironic that the bill is called SB 1776 because, the American Revolution was about opposing tyranny and having freedom and so on. And this bill does the exact opposite. It's ironically called the Compete Act, but it's really an anti-competition statute. What it says is there are specific ways you're allowed to compete and the ways you're not allowed to compete. And by the way, we explicitly mention that for us, the idea of competition is not about serving consumers in the market. It is about taking into account all these external stakeholders, whether it's competitors, workers, and so on. In a big sense, it operates as a competitor welfare standard. And when I say that, I don't just mean competitors in general, I mean specific competitors. Certain businesses may end up better off because their competitors are unable to take on different strategies that would help them get ahead of the curve. Certainly a business that is not trying to compete on price, doesn't want to see prices go down, from their opponents being deterred from, competing on price because of the, muddling the definition of what is predatory pricing, that would certainly benefit some firms. But the issue is if you're a small, developer or a small business and you're trying to enter the market, often the best thing you can do is do something very differently to what everyone else is doing. Whether that means offering much lower prices, maybe even running at a loss so you can try and get some market share. That is only predatory if, in the long run, you are doing it to eliminate your rivals and then drive up your prices later and make the money back. Because consumers are worse off under that outcome. And that's why we have that legal test the Supreme Court federally has set. What this act does is it says we don't care about that anymore. We're throwing that out of the window. We want to rewrite the wheel. Below cost pricing is predatory. That's a huge problem. What you're doing is you're making it not only making illegal pro-competitive business practices, you're creating a huge amount of commercial risk. Small businesses, they often don't have access to kind of legal resources, compliance resources, and so on that a bigger business would have. So now you're actually encouraging many of these small businesses to enter into arrangements or to be bought out by a bigger player so they can navigate this regulatory space. We know that regulations have a huge fixed cost. It's easy for bigger entrants to bear them and to survive. But also, if you're a bigger platform or a bigger player, and then you're affected by these requirements and they make it harder to do business, your incentive to invest in growing your platform is also diminished. Your incentive to work with smaller players is diminished. And that can harm the small guys too, because they rely on these platforms to try and get to their users. So you're making it harder for the small business to enter into exclusive arrangements, which will give a bigger player the certainty to partner and give them the resources they need. You're making it harder for them to compete on price. And finally, with regard to the so-called multi-sided transaction markets, I mean, this is really common sense, right? What value does Amazon have? What value does a credit card market have? It brings buyers and sellers together. That's the product. The transaction in itself is a product. This is not a radical thing. We've always tried to understand competitive dynamics from both the buyer and the seller side and try to weigh up the two sides together. There are situations where trying to lowball your supplier can harm consumers because you're restricting output. Federal law recognizes that. So what this bill does, it says, if you have bad effects on just one side of the market, that could be an anti-competitive effect. That could be illegal. So really, you are creating this absurd situation where you're inhibiting competition and you're harming small businesses while claiming that your goal is to do the opposite.
Thank you for that. And just to jump off one point that Satya mentioned about, like, often firms with lower market power, base their strategy not just on short-term profits, but on long-term profits, which is like whether it makes economic sense or not. Coming to you, Bilal, if my reading of AB 1776 is correct, I think it makes the plaintiffs, it doesn't require the plaintiffs to show that the defendant's conduct makes no economic sense. Does that, what does that mean, like, for when the law is actually interpreted in the courts? Would that mean that, like, if the economic factors are not analyzed by the courts, would arguably pro-competitive conduct be viewed as illegal under the current law, under the law as it's written?
Well, I think it does a number of things, right? First, it substitutes the court's judgment for proper business activity over the sense of the business, right? And I think courts should stick to interpreting law and not whether business decisions are economically or not economically rational, right? And so this will have the effect of expanding liability to businesses that engage in pro-competitive conduct, where efficiencies might be captured, might otherwise be captured and passed on to consumers, right? And it will look to liability not to whether the conduct makes sense for the, I'll call it the defendant, but whether the conduct in some way harms a competitor, right? And you don't want businesses thinking about how their behavior, how their competitive behavior, business choices will affect their competitors, right? What you want businesses thinking about is, how does this improve, my offerings to consumers, my services to consumers, getting my costs down. How does it help develop new products and get those products to market? And that's I think the critical benefit of the no economic sense test, right? The courts ask, does this conduct make sense from the perspective of the defendant, right? And if it does, there's a very high burden on the plaintiffs or the states to show that the conduct is anti-competitive, right? And that's a good thing, because we really don't want judges in the business of determining whether a business made the right business decision or not, right? Removing that no economic sense test framework, right, then really forces the business to think about, okay, is this going to harm my competitor, right? Is it, and that's a much different inquiry, and it's it may chill, right? It may chill, as I say, conduct that is otherwise competitive and welfare enhancing for consumers and for other participants in the market. So that's the big risk. So it'll expand liability for a broader class of business conduct.
It does sound like a fundamentally philosophical, different approach that it could lead to. I do have a bunch of other questions on 1776, but considering time, we're going to jump to SB 1074 and loop back, and we have time at the end. And I also want to mention for the attendees, if you have any questions, please use the Q&A function to submit questions. We will try to make time for some questions at the end as well. So going to SB 1074, the base stack, which is a bill that is similar to specific provisions in the DMA, EU's Digital Markets Act. Satya, can you set the foundation for us, look at the provisions of the base stack? How does it compare to the DMA? What does it mandate? Who does it affect? Can you give us set the stage for us?
Yeah, sure. So the base stack broadly targets a range of practices we call self-preferencing. So what it aims to do is it aims to ensure that certain large digital platforms, specifically based on size, to include 4 companies, Apple, Amazon, Google, and Meta, are not allowed to highlight or promote their own products or services over those of competitors on their own platforms, or to highlight and promote affiliates that they ally with their services and products over those of others on their platform. The idea being that whoever owns the stadium, and this really assumes that these companies have a level of market power without any need to actually check and verify that they actually have that power or that ability, should not be able to set the rules of the game. And like with the Compete Act, the other bill, what you're doing is you're inhibiting the margins on which these businesses can set the experiences on their platform, can use strategies to draw consumers, and can differentiate their products from each other. But at the same time, self-preferencing is usually good for consumers. What it does is it creates incentives for firms to enter into markets to vertically integrate. This leads to eliminating double marginalization. So, for example, when Amazon comes out with Amazon Basics, they are operating in two levels of the supply chain, and they don't have to levy a profit margin on two separate levels. They can do it at once. And this leads to efficiencies that can sometimes result in lower prices for the consumer. Amazon, or even a local supermarket, this is something that happens outside of the digital context, has been for decades. They have house brand products, right? And what they often do is they say, hey, we noticed that the sellers in our supermarket are, this product is really popular. They're making a lot of sales. What if we do our own version that's better or cheaper to make? Let's give that a go. Let's see how that goes. And this inevitably benefits consumers by giving them more choice and forcing those competitors to compete more effectively, lower their prices, improve their quality. And what's interesting is in the Amazon context, Amazon only enters into competition with 8% of the businesses in the US market. They have an incentive in most cases not to necessarily do that if they have a third-party seller's product that they make commissions off, right? So there's not this widespread problem where tech giants are just entering in and taking over markets. Although if that's what consumers prefer, that's what consumers prefer. You can't stop that. The DMA takes prohibits a wider range of practices. This targets especially things they've classified as self-preferencing, which would include Google linking to hotel bookings directly rather than going through third parties, things of that nature. I mentioned the Amazon example before. And there is an affirmative defense in the statute. So technically, once you've been accused and you're taken to court, the test, I believe, says that you bear the burden then of showing that the practice you're doing was reasonably necessary, narrowly tailored, non-pretextual, and had benefits that clearly outweigh the detriments. So some of this language is kind of ambiguous. It leaves it up to courts, depending on which way the judge is leaning, to try and interpret and contextualize it. There might be precedents elsewhere, but we don't know how that's going to play out. This creates uncertainty for the platforms. And then on top of all that, it's a much higher, more difficult standard to meet than your exclusionary conduct standard at the federal level. So really, we're going to see a chilling of activities, which by and large are proven to benefit consumers in most contexts.
Thank you very much for that. In particular, for ACT members and small businesses, the key for their success in digital markets is trust with consumers. And previously in an environment where the vehicle through which they reach their consumers was not clear, it was hard to establish trust. What they rely on is existing ecosystems where they can work with existing service providers and bigger companies to reach consumers at a faster pace, utilize the services that they offer, and really build upon the trust that the consumers have. That is critical for small business success. And that is a nuanced point that is often missed in the debate surrounding bills like the BASE Act and the EU's DMA and so on. I will come to the affirmative defense point in a bit. The BASE Act in particular, this is coming under discussion in other jurisdictions about extending digital markets regulation to the AI ecosystem. BASE Act in particular includes provisions, and Ted will come to you for this question. It includes provisions to essentially mandate neutrality of AI systems, including summaries that are generated using Gen AI, recommendation engines, and so on. We know that the AI technology is fundamentally different from traditional computing in the sense that it is probabilistic. It is not necessarily trained based on preset rules. What would the neutrality mandate mean for AI innovation? Like, is it even possible to meet this mandate based on technology as the way it is?
See how it will be possible. Yeah, I mean, this is a big problem. AI is not neutral in the sense that we use that term as lawyers. It's built on a lot of modeling assumptions that are needed to make it work rather than on what's needed to make it comply with legal standards that are going to come along sometime later. And, that's not unique to AI. We use econometrics in our antitrust analysis all the time. And I could say the same thing about that, during antitrust litigation. The attorneys get to beat up on the economists for assumptions that are built into their models that the economists often didn't consider. And that's a lot of fun for antitrust lawyers. But here we're just talking about evidentiary standards. Now, if we take this back into compliance, legal, the substantive sort of work that developers are actually doing rather than quality of evidence, then it really starts to become a big problem. Now the stakes are real in it. So we're going to end up with judges and lawyers who probably don't understand the technology, creating design standards for programmers who don't understand the compliance concerns, and they're going to get in trouble for using standard programming tools that haven't been subject to legal scrutiny before.
Thank you for that. That's definitely a valid point that as ACT members innovate in the AI space, it's harder for them to predict what the compliance environment is going to be, especially on vague laws that are written with technology not in mind. Coming to you, Ben, the base stack in particular also mentions certain like routine contractual practices, like it bans most favored nation clauses and margin guarantees and so on. From like kind of the California business community perspective, like especially for smaller businesses who are trying to secure like predictable terms, like how do they view these terms and what's their take on this?
Yeah, I'll just big picture and then dive in a little bit. I'm certainly not an antitrust expert the way everybody else on this Zoom is. But after dealing with this for the last few years at the Law Revision Commission, I feel like I could play one on TV at least. And candidly, this proposal had been contemplated by the Law Revision Commission, which in its own right has offered some pretty extreme recommendations, and even they said this would be so devastating to the state's economy that we would not recommend this at all. So, which is really telling, considering sort of how extreme the leadership of that commission is, that even for them this went too far. What's been interesting, I think, to me, and I know I'll certainly say to the bill's author, because he was very candid with me when he was introducing the bill. Basically, he thought he was going to have not, I don't want to say an easy time, but he thought he would try to paint this very easily as small tech versus big tech, essentially, and that the opposition was going to be limited to just a few companies, that you mentioned, and folks like Microsoft as well, who are sort of covered by this. I think he's been very surprised, in fact, by the opposition from the broader business community to this one. And although it does not directly apply to the tens of thousands of businesses here in California the same way 1776 does, the ripple effect and the impact on folks, I think, is as broad and impactful as 1776, and it's largely because of what you talked about, which is, I mean, it essentially breaks the e-commerce platform that we all know, and essentially banning all of these agreements and clauses that are pretty routine in business contracts today here in California. The bill's author said he wanted to break search, essentially. And then when he was asked what would replace it, he said, I don't know, maybe we could just list things alphabetically. So that gives sort of the insight into the types of that, this is really not well thought out. But the opposition, again, what we've heard from our members, and we represent, more than 15,000 businesses from the smallest to small to the biggest to big, is they are equally sort of scared of this proposal. And I've heard about it from folks in the airline industry. I've heard about it from folks, grocers, retailers, folks like that. Basically, anybody that sells anything on the internet is saying that these sort of the most favored nation clauses and some of the other contractual things that would be banned here, are how they run their business every single day. I spoke to a small business owner who's a member of ours yesterday, who's going to come testify on this next week, and she sells household goods to families that have developmentally disabled people in their household, so kids, adults, whatever it is, to make everyday living easier. And she said that between selling her goods on Amazon and other platforms, or people finding her through Google search or other search, that's 92% of her business. And she said, if I don't know what I would do, sort of without those agreements and without people being able to find me those ways. And so, I think she's got 2 or 3 employees. Again, this is a small business, literally operating out of somebody's home, that's doing really good work, and they are petrified of this. So yeah, I mean, again, this essentially breaks the e-commerce ecosystem as we know it, and that's why I think, again, certainly to me, even initially, I thought, oh well, I'll certainly hear from some of our bigger business members, but I've heard loudly from our small business members that they are equally petrified of this.
Thank you for that. And in particular, like policymaking without thinking through the downstream consequences, 2, 3 steps down the line leads to especially bad outcomes. And we are seeing that in Europe playing out, and that's the point I'll come
Yeah.
to.
We'd like people to be thinking 1 step down the line. 2 or 3 is really ambitious here sometimes, but I'll take 1 step down the line at this point.
Um, Bilal, coming to a specific point that Satya earlier raised about the affirmative defense approach that the BASE Act has, wherein it gives an affirmative defense. The standard for it is it requires a platform, once the plaintiff has raised a claim, to prove its conduct is narrowly tailored and that the pro-competitive benefits clearly outweigh the harms in the same market. I was just wondering, from your experience in private practice as well, like how difficult is it for a company to actually satisfy this burden in court, especially in digital markets?
Well, I think there are a couple of burdens here that anybody would have to address. One is, of course, the second guessing by the courts about whether this is, in a sense, the what I'll call the least restrictive way to implement, a plan or your conduct, right? I mean, that's a difficult question to answer. And it again may impose additional burdens on the defendant, not at the legal stage, but in thinking about the business decisions it makes, right? Which is there some other alternative, whether theoretical or conceptually developed, that a court or a plaintiff could come forward with that will undercut my rationale or reason for engaging in this conduct, right? So it can be a hard test to make workable in the firm's business decisions, right? Second burden is, the critics of the federal antitrust law have complained about the quantification of antitrust law, right? That plaintiffs have to show higher prices using complex econometric models. Well, there's some truth to that, not a lot of truth, but there's some truth to that. But that is also the same effect here as, proving future competitive benefits from business conduct in a broad sense is easy, right? You can talk about and show why you're doing it, the positive aspects of it, how it helps your consumers and customers, how it helps develop long run innovation, right? Quantifying that, weighing benefits versus costs, very complex, right? And leads to lots of litigation, high costs of litigation. and uncertainty, significant uncertainty, right? So again, businesses will be chilled in the decisions they make because of a concern about proving things down to these quantitative metrics, right? Another issue is, businesses don't operate usually in one market, right? And their decisions often have effects across multiple markets they participate in, right? And that's sort of intended, right? Now, if you're in the pharmaceutical space, maybe you're developing a particular molecule, but even there, you may have some spillover effects, some benefits in other markets, right? So in the but in the case of, sort of a broader class of businesses, you're often operating in multiple markets and trading off, how where you put your assets, where you put your investments, and focusing for purposes of finding liability, right? Taking a business decision which may affect multiple markets and saying, no, we're only going to look at the effects in one market, right? And not take account of benefits in other markets or benefits over time that we can't quantify today. All of this is going to make uh, proving, right, that your behavior, your conduct is pro-competitive much harder. So it has two effects. It imposes costs on firms, right? And not, again, you have to think about this bill in its entirety. It's not just monopolists, right? It's not just large firms. It's a much greater class of firms, right? So you're going to impose additional litigation costs on them and compliance costs. But I think more importantly, again, it's going to make them question, right, at the margin, whether they can show that conduct that they believe has consumer benefits, either over the short term or the long term, right? Can we prove to the satisfaction of a court, right, that we are correct? And that, at the margin, it's going to force firms to sort of pull back on things they do that affect competition and consumer welfare beneficially, right? I mean, the key thing to think about here is California has been the source of so much innovation in this country and in this world, right? These bills go right to the heart of the decisions that businesses make that encourage innovation, new relationships, and long-term productivity. To model the California legal system on a system that has been in place in Europe for now a few decades, where the Europeans themselves are questioning whether that regime has led to diminished innovation and diminished growth, and basically dropping them behind leadership of the economies and businesses in the US and Asia. And it is just incomprehensible, I think, to me, that California legislatures would adopt a model of competition enforcement that mirrors the slower growing, less innovative economies of the world, when they themselves are questioning whether they have wasted 2 to 3 decades trying to protect uh, consumers and firms from hard competition, right? And the effects of hard competition, right? Which can be disruptive, right? Which can be disruptive, but in the long run are what drives growth in the economy. I mean, just look at the separation of economic growth and productivity in the US versus Europe over the last 20 to 25 years. They are about 1/3 behind the US, and that gap has developed over the last 20 years when they have been focused on regulating competition and not removing the restraints on innovation and business decisions that are focused on long-term, aggressive implementation of competitive dynamics.
Thank you for that. And especially the point about a lot of the concerns here are not just purely theoretical. Like all we have to do is look at the experiment that has been done in Europe particularly with their antitrust law, which is philosophically fundamentally different from the US, but also specifically over the last decade or so with various ex-ante regimes, including the DMA, which was put in place a couple of years ago, has resulted in their digital markets fundamentally lagging back, and Europe themselves recognizing this through the Draghi study and so on. To that, I just want to come to you, Satya, quickly, if I may. I know you've studied on various services that are offered in digital markets, particularly in Europe, that have drawn back and pulled back because of the regulatory model there. Can you just, in particular, I know Google with the search functionality and like flight hotels and so on. Can you just speak to that just a little bit, over like 30 seconds to a minute or so, if you can?
Yeah, sure. So, the DMA has only been in place now for, I think, 2 or 3 years, but we're already seeing some evidence that it's really harming Europe's tech ecosystem. So for starters, certain features, AI-enabled features, especially on Apple and on Google as well, Google Search AI summaries, for example, were delayed by over a year uh, while they were rolled out in the US. And there's no reason for that other than really uncertainty around complying with this restrictive regime, which basically says competition is okay, but we'll tell you how you can and you can't compete.
Mm.
On Google Hotel Ads, I mean, this is really the best example of just how consumers are harmed, the platform's integrity is harmed, the value of the service itself is harmed because Google was prevented from linking directly to hotel bookings through Google Maps and Google Hotel Ads. Instead, they're forced to link customers through third-party booking sites. This might be great for those third-party booking sites because they're able to get traffic without having to earn it. But the issue is that for smaller hotels, the search friction means that consumers are less likely to go all the way through and book a hotel. And we've seen empirical evidence of this because bookings on Google Hotels dropped by over 30% and 36% in the European market. So, really, this isn't even succeeding in creating fairness for small businesses. It's picking some winners over other winners. We're seeing this play out in multiple areas.
Thank you for that. Before we jump to questions, we have a couple of minutes to talk about the merger reform, which merits its own webinar, really, which we likely will pick up in the future. As I mentioned, the merger reforms in California is currently with the California Law Revision Commission, which is at a proposal stage, where we commented and we sent letters to them on. And then they will subsequently potentially submit the recommendations to the legislature to pick up. I'll just come to you, Ben, on this quickly, if I may. To set the context, the merger proposals currently, there are 3 or 4 proposals. At the most extreme level, it would codify in California potentially and make inherently illegal merger transactions just based on pure market thresholds, amongst other problematic provisions there as well. Ben, we know that in California in particular, IPO account for less than 4% of venture-backed exits. As we always say for ACT members, blocking the path to exit is blocking the path to an entrance. And acquisitions make up like nearly 3/4. If the merger acquisitions proposals in California, like that makes it presumptively legal on structural grounds, if it makes through, what downstream consequences do we see for for early stage investment and startup formation in California?
I think I'm not being hyperbolic in terms of saying that, any progress that the Bay Area economy has made in recovery over the last few years, particularly in and around San Francisco, probably goes away. I mean, we're working with a couple of economists now to try to model what the impacts would be. But I think California's entire sort of ethos in terms of being the global leader in technology and innovation. This would probably be I don't want to say death knell is probably too strong a term, but I mean, the downstream impacts would be massive. I think just in terms of the outflow we've already seen of companies and VC firms, there's a whole host of, sort of public policy things going on right now. I think people probably read about some of it in the newspapers. But it would just be sort of devastating. And I think that it would really be the major driver for a lot of these, sort of smaller companies to just pick up and look for another place. Because there are a number of other jurisdictions that are aggressively trying to court folks. And being able to lean on well, we're still California and the California exceptionalism, um, uh, you know, uh, it would be simply devastating. So,
That's good to know, and we'll certainly pay attention to that process as it evolves with the CLRC. So I'll now jump to questions from the audience. We have a couple. And maybe the first question, just to think about policy at the federal level, I'll read it out verbatim. The federal equivalent to BASed, ACOA, which is the American Innovation and Choice Online Act, had very similar or the same requirements for its affirmative defense as the BASed Act. In digital markets, isn't it especially harmful to shift the burden to the defendant? For example, app stores and operating systems must take proactive measures to protect cybersecurity. This involves denying access to platform and only allowing access after vetting. Having to wait until there is a lot of evidence to meet the affirmative defense means you already have let in the cyber threats and harm that has been done. Does the problem apply to BASed as well? I'll throw it open to anyone, but maybe Satya, I think you may have thought about this as well.
Yeah, sure. So there are a number of laws, not just I mean ICO is a proposal, but I'm probably going to move a little bit also into another question that was asked about the Robinson-Patman Act, because I think this is really a great example of where you can say, hey, on paper we have a defense. If your costs are justified, or if doing this particular business practice is justified, go ahead, argue in court, and you're fine. The problem with that is even when courts have come in and said, this is okay, this is fine, here's a precedent that supports you, that doesn't stop often enforcers from going and bringing lawsuits. The Federal Trade Commission, for example, they brought a Robinson-Patman Act lawsuit. Robinson-Patman Act, for those who don't know, is anti-price discrimination lawsuit, statute, which has certain provisions which could be interpreted as punishing injury to competitors rather than injury to competition or injury to consumers. Basically, it prevents suppliers from giving favorable discounts to some buyers that they're not giving to other buyers. And it was designed to protect smaller buyers who don't have negotiating leverage from the depredations of bigger, more efficient rivals who are able to negotiate better prices. One of the defenses under that act is if you charge the bigger buyer a lower price, sorry, if you give them a better price because the cost of servicing them is less, then you're fine. It's called the cost justification defense. But even the Supreme Court has said that you have to come to court and you have to show empirically how, these are the costs that you have to undertake. This is how they've been reduced. And that's time consuming. Sellers often themselves don't have access to the information without having a deep dive into their own business. So the discovery costs involved, you're already stuck in court by this point. And it's incredibly expensive. And by then, a lot of businesses would simply have tried to settle to make the lawsuit go away. Now, what's interesting is the Federal Trade Commission recently brought a Robinson-Patman Act lawsuit against the country's biggest liquor distributor, saying, we think it's terrible that you're selling alcohol at a lower price to Walmart than you are to the boutique liquor store, because it's a smaller liquor store. At no point in the complaint does it allege that consumers are worse off or have higher prices. It simply says you're harming boutique liquor stores by selling at a lower price to Walmart. The FTC's own Republican commissioners came out last year saying, we're probably going to lose this lawsuit. We probably shouldn't even bring it because the defendant will prevail on a cost justification defense. They're still continuing with the lawsuit. So this just goes to show you that, even when there's more certainty about whether you'll prevail or not, you still are at risk when laws like this remain on the books, forcing you to say, hey, listen, doing this makes business sense. We should not be putting the burden that way. You're going to chill pro-competitive conduct, as Bilal mentioned, and smaller businesses will end up being harmed more than bigger ones in the long run.
Well, thank you for that. And that brings us to the 1 p.m. mark and 10 a.m. in Pacific time. I have a bunch of more questions, but we sadly ran out of time. I want to take this moment to thank you all again, the panelists, and for the audience for joining us. We certainly packed in a lot substantively in this 1 hour, and I can certainly see follow-up discussions on this as well. Thank you all so much for joining us, and please stay tuned for ACT initiatives on all of these proposals, and look forward to staying in touch. Thank you.
Thank you.
Thanks.